If you are a naturalized U.S. citizen and you believe your citizenship is permanent and untouchable, you are operating on a dangerous misunderstanding. That belief costs people everything. Here is what makes this so frightening: the people it happens to did not see it coming. They had been citizens for years, sometimes decades. They had families here, careers here, mortgages here, and then one morning the government knocked. In 2016, a federal audit revealed that roughly 315,000 fingerprint records had never been uploaded to the National Immigration Database. People who should have been flagged during background checks were instead approved for citizenship. The government response was Operation Janus. Investigators began working backward through decades of naturalization records, referencing criminal histories, deportation databases, and newly digitized fingerprint archives. Hundreds of denaturalization lawsuits followed. The dedicated Denaturalization Section at the Justice Department, the first of its kind in U.S. history, is still active today. The lesson is brutal and simple. The government can go back. There is no statute of limitations on denaturalization based on fraud. Something you did or were associated with before you ever came to America, something you may not have thought about in 30 years, can be used to take your citizenship away. This video covers all 7 legal grounds. By the end, you will know exactly where the risks are and what to do about them. Chapter 1, the law behind every citizenship loss case in the United States traces back to one statute. Section 349 of the Immigration and Nationality Act, codified at 8 U.S.C. Section 1481. It lists 7 specific acts that can cause you to lose your U.S. nationality. These are called expatriating acts. But here is the critical protection built into the law. The statute says you must perform these acts voluntarily, with the intent to relinquish nationality. That phrase, intent to relinquish, is everything. It came from a 1980 Supreme Court case called Vance v. Terrazas, where the court ruled that the government cannot strip a citizen of their nationality simply because they performed an expatriating act. The government must also prove by a preponderance of the evidence that the person did it with the specific intent to give up their American citizenship. The State Department followed up with a policy that presumes in your favor. If you get a foreign passport or take foreign nationality, the starting position is that you did not intend to give up your American one. The burden is on the government to prove otherwise. That protection is real, but it does not apply to denaturalization cases. And this distinction is where most people get confused. Expatriation under Section 349 covers things you do after becoming a citizen. The intent requirement applies. Denaturalization under Section 1451 is different. It covers cases where the government argues your citizenship was obtained through fraud or misrepresentation in the first place. Under that theory, there is no intent requirement. The government simply needs to prove the original fraud. And the Supreme Court confirmed in Fedorenko v. United States that even unintentional concealment of a material fact can support denaturalization. You do not have to have deliberately lied. A good faith mistake on your application form is enough. Chapter 2 Reasons 1 and 2. Foreign nationality and military service. Reason 1. Obtaining foreign nationality if you voluntarily apply for citizenship in another country. That is a potentially expatriating act under Section 349. The key word is voluntarily. Nationality you received at birth, or nationality that attaches automatically by law without any application, does not carry the same risk. The danger is in the affirmative act, signing an application, going through a registration process, completing forms that seek foreign national status. For Chinese Americans of Taiwanese heritage, this comes up constantly. Many people are technically entitled to ROC nationality by descent. Simply being entitled to it creates no problem. But formally applying to re-register, claiming that nationality, or renewing a Taiwan national ID card, particularly if any of those steps involve signing language about loyalty to the Republic of China, moves into legally significant territory. For Chinese Americans with mainland connections, the PRC does not officially recognize dual nationality, but Chinese authorities sometimes issue or renew Chinese identity documents to individuals who have already naturalized in the United States. The legal status of using those documents is genuinely unsettled, and the safest rule is this: before taking any affirmative step to obtain, renew, or register for nationality in any foreign country, consult a U.S. immigration attorney who specializes in nationality law first. Reason 2, Foreign Military Service Section 349, makes it an expatriating act to serve as a commissioned or non-commissioned officer in any foreign military, regardless of whether that military is hostile to the United States. Basic enlisted service in a foreign military that is not fighting America is generally not enough on its own. But officer level service, including reserve commissions, meets the threshold. for Taiwanese. American men, this is a practical reality. The Republic of China maintained mandatory military service for male nationals for decades. If you completed basic conscript service at the enlisted level, the statutory threshold for Track 2 expatriation may not be met. But if you were promoted to a non-commissioned rank during that service, or if you hold a reserve officer commission of any kind, the analysis is entirely different. An officer commission in the ROC military, even in a reserve and inactive capacity, is an expatriating act under the statute. The Terraza's intent requirement still applies, but holding a formal commission is much harder to characterize as something you did without understanding the significance. If any of this applies to your situation, the time to get a legal opinion is before your next U.S. passport renewal, before any federal job application, and before any security clearance process, not after the flag appears. Chapter 3 Reasons 3 and 4, Renunciation and Treason. Reason 3. Documents you signed without fully reading them. Formal renunciation before a U.S. consular officer is a deliberate, multi-step process. Nobody does that accidentally. But there is a different and far more realistic version of this risk that immigration attorneys see regularly in the Chinese-American community. People sign documents at Chinese consulates. They go in to help a parent renew a passport. They sign household registration updates. They complete inheritance paperwork. They fill out property-related civil filings. These documents are in Chinese. The stack is thick. The consulate staff moves through the forms efficiently, and buried in the boilerplate of some of those documents is standard legal language about nationality status or loyalty to the People's Republic of China. Signing such a document does not automatically cause you to lose your citizenship, but it creates a record. And in the context of any subsequent investigation or proceeding, that document can be used as evidence bearing on the intent question in an expatriation analysis. The people who end up in the most difficult situations are those who signed something years ago that they barely remember, and who now have to explain without documentation what they understood at the time. The rule is simple. Never sign any document at a foreign government office without reading it completely in a language you are fully comfortable with. If you are there to help a family member, maintain a clear distinction between documents you are signing as a helper and documents you are signing in your own name. If you have already signed something you did not fully understand, write down your account of those circumstances. Now, in detail, while your memory is fresh. That contemporaneous record is valuable. Reason 4, Treason, Sedition, and the online record Section 349 Cross. References federal criminal statutes covering treason, sedition, and advocating the violent overthrow of the U.S. government. For most people, this is not a realistic concern. Courts interpret these statutes narrowly, and the First Amendment protections for political speech are robust. But two things are worth flagging for this community specifically. First, formal affiliation with organizations that have been designated as foreign agents or foreign influence operations under U.S. law creates exposure. This is not about ordinary cultural, alumni, or community organizations. It is about entities that have been specifically named by U.S. authorities as operating on behalf of foreign governments. If you hold any formal role in such an organization, consult an attorney. Second, your digital history. Content that explicitly advocates violent action against us institutions, or that expresses formal support for organizations hostile to the United States, can surface years later in the context of an investigation you did not anticipate. The standard for what crosses a legal line is high, but a background investigation does not apply the same standard as a criminal trial. It applies a judgment call by an investigator reviewing everything they can find. If there is anything in your online history you would not be comfortable explaining under those conditions, document your context and intent. Now Chapter 4, Reason 5, Fraud on your naturalization application. This is the reason that applies to the largest number of ordinary law-abiding Chinese American citizens. Not because anyone committed intentional fraud, but because the N-400 naturalization application form is long, was filled out in a second language years or decades ago, often without legal help, and contains questions whose legal scope is far broader than a common sense reading would suggest. 3 facts make this the most dangerous ground of all. There is no statute of limitations. The government can bring a case 30 years after your naturalization. Material is defined very broadly. A fact is material if a reasonable USCIS officer might have wanted to know it, not necessarily if it would have changed the outcome. And intent is not required. Even an honest, good-faith mistake in answering a question can support a denaturalization case under the Fedorenko standard. The questions that create the most risk for Chinese American applicants fall into 4 categories. The first is organizational memberships. The N-400 asks whether you have ever been a member of or associated with any organization, association, party, club, society, or similar group anywhere in the world. The word ever means what it says: Communist Youth League membership, which was near universal for academically successful Chinese students of certain generations, appears frequently in denaturalization cases because the government treats SIL as formally affiliated with the Chinese Communist Party. University-level party organizations and mandatory work, unit political study groups carry similar legal significance in government analysis, even though participation was often obligatory and politically meaningless to the individual involved. The second is government employment. The N-400 asks whether you have ever worked for or been associated with any government in any country. In China, the line between government employment and private employment is not always obvious. Employment at a state-owned enterprise, a public university, a government research institute, or a company with significant state ownership may fall within scope of this question. Many applicants answered no because they thought of themselves as working for a company, not for a government. The government may see it differently. The third is military service. The question covers any armed forces in any country. Mandatory military-style university training in China does not qualify, but formal service in PLA reserve components or the People's Armed Police may, depending on the specific role and the government's characterization of the organization. The fourth is criminal history. Arrests that were dismissed, charges that were expunged, traffic offenses that resulted in court appearances, and foreign convictions all potentially fall within scope of the disclosure requirements. The standard is broader than most people assume. Your action plan for this chapter is specific. Obtain a copy of your original N-400 by filing UCI's form G-1041, which is a free FOIA request. Read every question. For any question where your current understanding of the scope would produce a different answer than what you submitted, note it. Write out a detailed factual account of any organizational affiliations, government employment, or military-adjacent activities from your life before immigration. Then bring all of that to an immigration attorney who specializes in denaturalization defense. Do not try to correct the record on your own. Do not write to assessors without counsel. Unsolicited disclosures made without legal guidance often create more problems than they solve. Chapter 5 Reasons, 6 and 7, Tax Crimes and Criminal Conviction. Reason 6, Undisclosed foreign financial accounts, tax evasion, and FBAR violations are not listed as independent expatriation grounds in Section 349. But they create a pathway to denaturalization through a different channel, and that pathway has been used. If you have willfully concealed foreign financial assets, and those assets are connected to activities or affiliations that were material to your naturalization application, the government can argue that your concealment of those underlying facts constitutes material fraud in your naturalization. The argument is not just that you failed to report bank accounts. It is that those accounts reflect ongoing relationships with entities or individuals you failed to disclose on your N-400, and that the deliberate concealment is evidence of consciousness of guilt. The FBAR requirement is simple in concept, but widely misunderstood in practice. If you are a U.S. person and you have a financial interest in or signature authority over foreign financial accounts with an aggregate value exceeding $10,000 at any point during the year, you must file FinCEN Form 114 annually. The $10,000 threshold is aggregate across all accounts. 3 accounts holding $5,000 each trigger the requirement, just as clearly as one account holding $30,000 signature authority over a family business account in China counts as your account for FBAR purposes. Balances in WeChat Pay and Alipay may count depending on the aggregate amount. The penalties for willful failure to file are severe, up to $100,000, per volt iolation, or 50% of the account balance per year, whichever is greater. And since FATCA was enacted in 2010, major Chinese banks report us, person account information directly to the IRS. The gap between what people think the government knows and what the government actually knows has closed dramatically. The Offshore Voluntary Disclosure Program, which gave people a formal pathway to come into compliance before the government found the problem on its own. Closed permanently in 2018, the streamlined filing compliance procedures are still available for genuinely non-willful non-compliance. If you have undisclosed foreign accounts, engage a tax attorney now, not a CPA, an attorney with privilege to assess your exposure and identify the right pathway. Reason 7, criminal convictions. Specific criminal convictions can be used as evidence in denaturalization proceedings, particularly when those convictions reveal information that was material to the naturalization application and was not disclosed. The highest risk category involves convictions for offenses with foreign government connections, including espionage, unauthorized foreign agent activity, and technology export violations. If a conviction demonstrates an ongoing relationship with a foreign government that predated naturalization, the government can argue that relationship was material and was concealed on the N-400. The second category involves convictions for fraud or identity offenses, where the same false information that produced the conviction may have been present in the naturalization application. The third category involves offenses that occurred during the good moral character period, generally the 5 years before the naturalization application was filed, that were not disclosed. A conviction during that period that was not reported is treated as material fraud regardless of whether it would have changed the outcome. If you have any criminal history that was not disclosed on your N-400 for any reason, including a good faith belief that it was outside the scope of the question, consult an immigration attorney to assess the materiality of the omission. Chapter 6, your 7-point protection plan. The difference between the people who navigate these issues successfully and the people who do not is almost never about the underlying facts. It is almost always about preparation. Point 1. Review every foreign nationality document you have touched since becoming a U.S. citizen. Foreign passport applications, household registration updates, nationality certificates, inheritance filings. For any document that contained language about nationality or loyalty, retrieve a copy if possible. If you obtained any foreign nationality document after naturalization, consult an immigration attorney before your next U.S. passport renewal. Point 2. Know your military status. If you hold any reserve commission or active rank in a foreign military, get a nationality law opinion before any federal job application or security clearance process. Never accept a foreign military officer commission without a prior written legal opinion on the citizenship implications. Point 3. Account for every document you have signed at a foreign government office. If you signed anything containing language you did not fully understand, document your account of those circumstances in writing. Now, never sign documents at a foreign consulate without reading them completely or having them translated and explained by someone who understands both the language and the legal significance. Point 4. If you have any historical affiliation with an organization that has since been designated as a foreign agent or influence operation, consult an attorney before that affiliation surfaces in a context you did not choose. Point 5. Get your N-400 and read it. File USCI's form G-1041 if you no longer have your copy. Go through every question with your current understanding of the scope. If anything would produce a different answer today, consult an immigration attorney who specializes in denaturalization defense before taking any other action. Point 6. Complete a full inventory of every foreign financial account you have held since naturalization. Check whether you filed FBARs for each year the accounts were open. If you find gaps, engage a tax attorney to assess your exposure and identify the right compliance pathway. Point 7. Compile your complete criminal history across every jurisdiction and country. Include dismissed charges, expunged convictions, and minor offenses that resulted in court appearances. Compare it against what you disclosed on your N-400. Any gap warrants a conversation with an immigration attorney. U.S. citizenship is among the most valuable legal statuses in the world. For most people watching this, it was also among the hardest earned. Years of patience, paperwork, waiting, and building a life in a country that was not the one you were born in. It deserves to be protected with the same seriousness and intentionality it took to obtain. The 7 risks covered in this video are real. The enforcement infrastructure has been built. The government's ability to reference decades of records is greater than it has ever been. And the communities most affected are not criminals or bad actors. They are ordinary people with complicated histories who filled out forms in a second language, made reasonable decisions under pressure, and never thought twice about it. If anything in this video gave you pause, do one thing: call an immigration attorney who specializes in U.S. nationality law. Find one through the American Immigration Lawyers Association at ila.org. The consultation takes 2 to 3 hours. In the majority of cases, you will leave knowing your situation is clean and why. That clarity is worth every dollar. Share this video with someone who needs it. Your parents who naturalized years ago and have never thought about any of this. Your friends who are in the middle of the process right now. Your colleague who mentioned last week that they have a bank account back home they have never gotten around to reporting. The conversation is not comfortable, but it is far less uncomfortable than the alternative.